This story is fictional. Any resemblance to real people or events is purely coincidental. 1. On the morning Boston expected Evelyn Harrow Whitmore to arrive looking defeated, she stepped out of a black car in a silk dress chosen for another woman, carrying a leather folder slim enough to be ignored and dangerous enough to ruin a dynasty. The courthouse district had the particular winter sheen that made power look clean from a distance. Brass doors reflected pale light. Men in camel coats walked fast with their collars turned up. Assistants balanced cardboard trays of coffee like offerings to gods who billed by the hour. By 9 o'clock, people in Beacon Hill, drawing rooms, and corner offices had already begun their quiet morning sport of prediction. They expected a tasteful collapse. They expected the wife of Graham Whitmore to appear strained, oversensitive, too expensively composed, and just brittle enough to confirm everything Boston's old families like to believe about women who spent nearly 2 decades beside ambitious men. Decorative in public, emotional in private, replaceable in crisis. Evelyn knew the script because she had written cleaner versions of it for juries. 18 years earlier, before the children, before the townhouse on Mount Vernon Street, before the dinners where judges smiled too long and donors pretended not to notice who was truly doing the intellectual work, she had been the one professors remembered. She had the steadier mind, the deeper instinct for contradictions, the rare patience to build a case from fragments and silence. Graham had the face, the family name, the ease in a room lined with portraits of dead benefactors. He had charm that people mistook for authority. Evelyn had authority that people preferred not to notice unless their reputations depended on it, so she made what everyone later called a graceful sacrifice. It never felt graceful from inside. She told herself it was temporary when their first son was born during the same year Graham's father began handing him real files at Whitmore, Reed & Vale. She told herself she was merely stepping sideways, not down. She told herself legal strategy could be practiced from the shadows just as effectively as under courtroom lights. In some ways, she had even proved it. Motions sharpened under her pen. Witness outlines became lethal after she touched them. More than one celebrated Boston divorce attorney built a winning theory from memos Evelyn drafted at the long dining table after midnight, while sterilized bottles cooled beside stacks of exhibits. Graham learned early that his best arguments arrived not during office meetings, but on yellow pads left beside his coffee at dawn. He never thanked her in a way that counted. Men like Graham treated gratitude as a small, dangerous concession. Acknowledging the architecture beneath them would mean admitting they had not built the house alone. For years, she accepted the arrangement the way intelligent women in old cities often do when the rewards are polished enough to resemble respect. There were schools with ivy on the walls, summers on the Cape, charity galas, and the firm itself, always described as a family institution, even when it behaved more like a kingdom. She knew every partner's habits, every spouse's grievance, every client whose public values differed wildly from private behavior. She knew which judges hated lateness, which trustees drank before noon, which mergers were kept afloat by handshake favors and generational debt. Graham liked to think his ascent through the firm had been inevitable. Evelyn knew it had edited. The affair, when she finally uncovered it, was vulgar mainly in its predictability. Not because the other woman, Camille Mercer, was young, though she was. Not because Camille had been pulled upward with suspicious speed, though she had. It was vulgar because Graham had chosen the oldest fantasy available to an aging man in a city obsessed with pedigree, renewal through admiration. Camille looked at him as if he were still ascending. Evelyn looked at him and saw the scaffolding. The first evidence had not been perfume or lipstick or some theatrical carelessness. Graham was too disciplined for cliches. It had been an invoice, a boutique on Newbury Street, charged to a corporate card under an entertainment category broad enough to hide flowers, dinners, apartments, and mistakes. Evelyn almost missed it among a stack of statements she reviewed out of old household reflex. The amount was high, but Boston wealth often disguised indecency as taste. What made her pause was the item code: custom alteration, rush order. She knew that boutique. She had once been fitted there for a judge's benefit. She also knew the date. Graham had told her he was in Hartford for a client dinner. A lesser woman, this was how certain people in her circle would later imagine it, might have started with outrage. Tears in the bedroom, a smashed glass, a midnight demand. Evelyn began with records. Within 10 days, she had the apartment lease in Back Bay, routed through an LLC so thin it nearly offended her. Within 2 weeks, she had expense patterns, dinner reservations, ride receipts, and a set of internal emails that would have been harmless if viewed separately and catastrophic when placed in sequence. Within 3 weeks, she understood the full design. Graham was not merely unfaithful. He was preparing a transition. He intended to elevate Camille to partner, cast Evelyn as a dependent wife with inflated habits, and use the divorce to cut her off from the life she had helped build, while preserving the firm, the clients, and his public image as the reasonable man burdened by a difficult spouse. That had been the real injury, not sex. Strategy. He meant to erase authorship. He meant to convert 18 years of invisible labor into a story about his generosity. The legal papers that followed were almost elegant in their cruelty. Asset structures tilted, trust assumptions hardened. Household contributions vanished into language designed by men who had always assumed caregiving was a sentimental hobby rather than economic force. The filing painted Evelyn as peripheral to the firm, ornamental to Graham's success, and financially cushioned by his benevolence. When she read that last section, she felt something inside her cool to a level that was almost serene. She stopped grieving and began inventory. The firm's founding archive was stored partly downtown and partly in an off-site vault because old Boston institutions loved records the way aristocrats loved silver, not for use, but for continuity. Evelyn requested copies under the pretext of trust planning. No one questioned her. Wives were invisible until they were useful. She reviewed incorporation papers, amendments, side letters, donor pledges, and client onboarding documents from years when Whitmore, Reed & Vale had been smaller, hungrier, and more vulnerable. Back when Graham's father had still understood risk. Back when Evelyn had not yet learned how thoroughly her mind would be borrowed. That was where she found the appendix. It was old enough to be dismissed by careless eyes, buried beneath funding instruments from the firm's expansion period, signed during the year of their second child's birth, when Evelyn had been too sleep-deprived to remember half the documents crossing the dining table. Yet there it was, crisp as a blade in old linen. A trust-adjacent client acquisition mechanism tied to initial capital shielding and referral protections. Several cornerstone accounts, the kind that gave the firm its legitimacy in elite family litigation, had not entered through the Whitmore name alone. They had entered through a quiet vehicle established in Evelyn's family trust after one of her late aunt's estate relationships opened the door. The appendix was dull on the surface and devastating underneath. It established not only origination weight, but a governance condition linked to ethical exposure and reputational harm. In plain English, though the document would never permit such vulgar clarity, if a named principal endangered the firm through misconduct involving misuse of firm funds and compromised client confidence, a control mechanism could be invoked by the trust-linked party with standing. Her standing. Evelyn sat alone in the library that night with the appendix laid flat beneath a green-shaded lamp while snow moved softly against the window panes. Somewhere upstairs, one of her sons slept with his headphones on. Somewhere across town, Graham was likely believing the future was already arranged. Boston men like him often made the mistake of confusing a quiet woman with an unprepared one. By the time the deposition morning arrived, she had built her file with the precision of a demolition engineer. Not large, not dramatic, no wasted paper, a few account statements, a few authorizations, a chain of reimbursements, internal messages, governance documents, the appendix. Enough to change the mood in any room from condescension to terror. She entered the conference floor of a private litigation suite rather than the public courtroom people like to imagine. Frosted glass, muted carpet, oil paintings so harmless they looked expensive. Associates moved around her with studied neutrality and hungry eyes. They knew scandal when they smelled it, and Boston legal culture fed on scandal the way old money fed on tax exemptions. Her own counsel, Miriam Sloane, rose when Evelyn appeared, and for the first time that morning allowed herself the smallest flicker of surprise. It was the dress. Midnight blue, impeccably cut, severe enough for litigation, memorable enough to land like insult. Evelyn had recognized it from the invoice, then confirmed it through a sales associate who underestimated wives over 40. It had been intended for Camille. Graham had paid for it through the firm. Somehow, that detail pleased Evelyn more than it should have. Not because it was petty, though perhaps it was, because it restored proportion. Men like Graham believed they alone could choreograph humiliation. At the far end of the hall, a conference door opened. Graham stepped out with the composure of a man who had spent his life being welcomed into rooms he did not deserve. He was silver at the temples now, handsome in the approved Boston manner, carrying fatigue like an accessory. One glance at Evelyn should have reassured him. Instead, he stopped. His gaze moved from the dress to her face to the slim leather folder in her hand. For the first time in 18 years, Evelyn watched her husband realize he had no idea what she knew. 2. He recovered quickly because men like Graham had been trained since prep school to recover in public, but Evelyn still saw the fracture before it sealed. It flickered at the edges of his mouth, in the tiny pause before he adjusted his cuff, in the slight overcare with which he said good morning, as though tone itself could restore command. Around him, the machinery of elite litigation kept moving. Junior associates carried binders. A court reporter was escorted down the hall. Someone laughed too softly at something not amusing. Yet the air had changed. One misplaced detail could do that in a room full of lawyers. A dress could be an accusation. A pause could be evidence. Evelyn offered him no rescue. For years, she had rescued Graham from small embarrassments before they ripened into consequences. She had corrected citations in briefs after midnight so judges would never know he had been careless. She had rewritten letters to clients so their trust in him would remain uninjured. She had anticipated questions for partnership meetings and fed him polished answers over breakfast while their sons argued over cereal. She had even in the early years protected him socially, smoothing over his flashes of vanity with women who enjoyed proximity to Whitmore prestige. It struck her now, with almost anthropological detachment, how much of marriage in certain circles was simply reputation maintenance performed by wives in rooms no one thought to count. No one in the corridor mentioned the dress. Boston civility was too evolved for that. But several people noticed. Evelyn saw recognition in one assistant's widened eyes, in the glance exchanged by two mid-level partners passing toward the elevators, in Miriam Sloane's decision not to ask any questions. There was no need. The point had already landed where it needed to land. Graham knew. Evelyn knew that he knew. Anything spoken aloud would only cheapen it. Inside the conference suite, the long walnut table was set with pitchers of water and legal pads embossed with the firm's discreet stationery. Whitmore, Reed, and Val liked to conduct destruction with tasteful tableware. The room overlooked a thin slice of downtown Boston, rooftops and church spires under a washed winter sky. Graham's counsel, Daniel Mercer, stood at the far end arranging exhibits with the serene confidence of a man who believed facts were flexible so long as billing rates were high enough. He had built half his career guiding rich husbands through divorces without visible blood. His specialty was narrative positioning. Frame the wife as emotional, vague, extravagantly accustomed to comfort. Frame the husband as burdened but fair. Reduce unpaid labor to atmosphere. Convert dependence into character flaw. Daniel had likely prepared all morning for a fragile spouse. Instead, he got Evelyn. She took her seat without fuss, removed her gloves, folded them with care, and placed the slim leather folder beside a yellow pad. She had learned long ago that the most intimidating people in legal rooms were rarely the loudest. They were the ones who arranged their objects as if time belonged to them. Miriam settled at Evelyn's left, suddenly efficient and still. Across from them, Graham sat beneath the framed abstract painting the suite rented to appear modern. His tie was impeccably knotted. His wedding ring was gone. That absence might once have hollowed her out. Now it looked administrative. The court reporter began with routine instructions. Swear the witness. State the appearances for the record. Let the machinery establish its polite fiction that everyone present was merely here to clarify facts. Evelyn listened with the old, sharpened attention she had not used in years, and it felt less like rediscovery than return. Her mind moved exactly as it always had when pressure entered a room, noticing omissions, mapping motives, hearing not just what was said, but what the speaker hoped silence would hide. Daniel began gently. He wanted history before combat. How long had she been married? What had been her role in the household? Had she maintained outside employment during the marriage? Had she been compensated by the firm in any formal capacity? Had she held herself out as an attorney of record in any matter before the Massachusetts courts? The questions were clean on the surface and deeply strategic underneath. Evelyn almost admired the craftsmanship. Every answer he sought would support the same architecture. She had not appeared in court, had not been billed as counsel, had not drawn partner compensation, had not occupied a recognized title. Therefore, she had not materially contributed to the engine that generated Whitmore wealth. Therefore, any settlement could be structured as provision rather than division. She was meant to sound adjacent to her own life. Evelyn answered truthfully and let the truth remain incomplete exactly where it needed to. Yes, she had stepped away from litigation after the birth of their first son. Yes, her name did not appear as attorney of record on the firm's active dockets. Yes, much of her work had been informal, internal, or advisory. Daniel relaxed almost imperceptibly after the first half hour. Men like him mistook composure for surrender whenever it arrived in a female voice. Then he moved to money. Would she agree that the family's standard of living had been funded primarily through Graham's income and partnership distributions? Would she agree she had enjoyed the privileges associated with that income, including real estate, travel, household staff, private education, club memberships? Would she agree that Graham had, throughout the marriage, borne the principal economic burden? Miriam objected where required, but the deposition rules were generous to predators. Evelyn understood the shape of the trap. If she pushed back too emotionally, she became bitter. If she conceded too neatly, she became dependent. So she did something Daniel did not expect. She answered with dates. She described years, not feelings. The year Graham first inherited active client contact from his father. The year the firm expanded its family litigation department. The year 2 cornerstone accounts came in through estate relationships on her maternal side. The year she reorganized a trial chronology that salvaged a collapsing custody matter for one of the firm's most politically connected clients. The year she began reviewing draft strategies from home after midnight because Graham's success had outpaced his discipline. She never raised her voice. She simply introduced chronology into a room designed to flatten her into category. Daniel tried to steer her away. He asked whether she had documentary proof that her strategic suggestions were essential to outcomes. Evelyn almost smiled. Essential was not a legal standard, and men often reached for the wrong word when confidence outran caution. She said there were memos, tracked drafts, annotated binders, archived comments, witness outlines, and several generations of document versions stored in ways that reflected the firm's digital migrations over the last decade. She added that she assumed discovery would surface them if counsel considered them relevant. Across the table, Graham did not move, but Evelyn knew his stillness. It was the stillness of a man listening for the first creak under floorboards he believed were solid. Daniel changed direction. Affairs were ugly but common. Perhaps he meant to contain it there. He asked whether marital tensions had caused Evelyn to become suspicious of ordinary professional mentoring between Graham and younger colleagues. He asked whether she had misinterpreted business dinners or travel as something improper due to emotional strain. He asked whether she had any direct personal knowledge of misconduct or was relying on assumptions. At that word, assumptions, something almost pleasant moved through Evelyn. She reached for her water, took one measured sip, and set the glass down with care. Then she answered that she preferred documents to assumptions. There were expense reimbursements charged to firm accounts for non-client dinners, wardrobe purchases, apartment-related expenditures routed through an intermediary entity, and travel irregularities that did not correspond to client billing records. She said this as if she were identifying weather patterns, not detonating a marriage. The court reporter's fingers kept moving. Miriam did not look at her. Daniel's pen stopped. Graham finally spoke, not to her but to his counsel, asking whether this line of inquiry was relevant to the agreed scope. His voice was smooth, but he had made the oldest mistake in deposition practice. He had revealed concern before the question required it. Miriam answered before Daniel could recover. If firm funds had been used for non-firm purposes, and if marital assets had been concealed, the relevance was obvious. Her tone was mild enough to be dangerous. The next 10 minutes were the first true shift in the room. Daniel attempted containment through technicality. Had Evelyn personally reviewed the general ledgers? Was she qualified to interpret billing codes? Could she identify the sources of her information without exposing privileged material? Evelyn answered each question with the patience of someone who had spent 18 years watching men confuse complexity with defense. She had not hacked anything. She had reviewed marital financial disclosures, routine household records, reimbursement statements mistakenly forwarded through a shared archive, and publicly obtainable property records. As for qualification, she said she had spent nearly 2 decades around domestic litigation, finance, and governance procedures. Not formally employed, of course, merely attentive. Daniel's expression hardened with the first hint of real respect, which, in his case, looked like dislike. And still, Evelyn did not open the leather folder. That folder had become the center of the room without anyone naming it. Graham's eyes touched it and moved away, touched it again. He was trying to calculate what she had, what she understood, what she might be bluffing. In the first years of their marriage, he had loved that she was difficult to surprise. Later, he had resented it. Resentment had finally ripened into the conviction that motherhood and social exile had dulled her. Men who benefited from women's endurance often mistook endurance for erosion. Daniel made one more attempt to reduce her. He returned to the familiar terrain of domesticity. Since leaving full-time professional work, had Evelyn not devoted herself primarily to the home? Was it fair to say Graham's career advanced because he carried the commercial risk while she enjoyed flexibility? Had she, in fact, ever wanted the pressures of partnership life? The question was elegant in its cruelty because it translated sacrifice into preference. Evelyn looked at him then, fully, and for the first time all morning, a few people in the room seemed to understand that they had not been questioning a discarded spouse. They had been underestimating a case builder. She answered that wanting and choosing were not always the same under the pressure of children, legacy families, and institutions that welcomed female intelligence mainly when it arrived unsigned. She said she had not merely supported Graham's career. She had structured portions of it, protected portions of it, and on more than one occasion, corrected weaknesses that would have cost the firm dearly if left untouched. Then, after the smallest pause, she added that the record on that point was far broader than opposing counsel yet understood. Graham's hand tightened once on his pen. No one spoke for a breath. Then Evelyn opened the folder just enough for the old cream paper inside to catch the light, and Daniel Mercer's confidence changed shape before he even saw a single page. 3. The paper inside the folder was older than the room's furniture and quieter than any evidence Daniel Mercer expected to see that morning. Old documents carried a particular gravity in Boston legal culture. The city had built entire reputations on the quiet authority of yellowing signatures and forgotten clauses. New lawyers chased headlines. Old lawyers feared archives. Daniel knew that. Evelyn could see it in the way his eyes shifted from her face to the edge of the exposed page and then to Graham, as if confirming that whatever rested inside that folder belonged to the category of things that should have remained buried. Evelyn did not slide the document across the table yet. Timing, she had learned long ago, was the real craft of litigation. Evidence alone rarely changed a room. Evidence revealed too early only provoked denial. Evidence revealed too late looked theatrical. The moment had to arrive when people began asking themselves questions before they were asked out loud. The deposition continued. Daniel regained control by shifting back to procedure. He asked Evelyn to describe the nature of the trust assets she had referenced earlier, the ones associated with her maternal family. He asked whether those trusts had any operational relationship with Whitmore, Reed, and Vale. He asked whether she had ever claimed ownership of any client relationships connected to those instruments. On the surface, the questions looked like clarification. Underneath, they were reconnaissance. If Evelyn believed the trust somehow gave her leverage over the firm, Daniel wanted to know the theory before it appeared in court filings. Evelyn answered carefully. Her maternal family had maintained estate trusts for several generations. One of those trusts, had once administered philanthropic and financial relationships with several Boston families, whose legal affairs eventually moved to Whitmore, Reed, and Vale when Graham's father expanded the firm's family litigation practice. The transition had occurred during a delicate period when the firm needed credibility with certain old clients who valued continuity over innovation. Daniel nodded politely, though the explanation sounded harmless enough. Firms received referrals from family relationships all the time. It meant little unless the relationship had been formalized. Evelyn noticed the subtle relaxation around the table. This was exactly the misunderstanding she had anticipated. She closed the folder again, almost casually, and rested her hands on it while Daniel continued his questioning. The movement had the quiet authority of someone placing a chess piece while the opponent was still studying the board. Daniel moved to another line of inquiry. Had Evelyn ever negotiated compensation or ownership within the firm during the marriage? Had she ever been promised equity? Had she ever requested formal recognition for the advisory role she now described? The questions were clever. If she admitted there had never been an agreement, then everything she claimed became emotional labor rather than legal entitlement. Evelyn answered with a calm that made Miriam glance at her once. She said she had never requested equity. She had never negotiated compensation. She had never insisted that her contributions be documented in the firm's partnership structure. Daniel almost smiled. Then she added that the absence of such negotiation had not prevented other documents from acknowledging her legal standing in more structural ways. The smile faded. Daniel leaned forward slightly. Graham did not move at all now. Evelyn lifted the first page from the folder and placed it gently on the table. The paper was an appendix to an early governance amendment filed during the firm's expansion period almost 17 years earlier. The signatures at the bottom included Graham's father, 2 founding partners, and a trust officer representing Evelyn's maternal estate vehicle. Daniel scanned the page with professional efficiency, but the moment his eyes reached the 3rd paragraph, his posture changed. It was a short clause. Short clauses were always the dangerous ones. The paragraph described a referral trust arrangement that had been quietly implemented during the firm's restructuring phase. Several major client families had agreed to move their legal matters to Whitmore, Reed & Vale under the condition that referral oversight remained tied to the originating trust network. That trust network, the document clarified, operated through Evelyn's family estate vehicle. More importantly, the clause specified a governance safeguard. If a named managing partner engaged in conduct that jeopardized the firm's ethical standing or financial integrity, the referral trust retained the right to trigger a review process capable of suspending that partner's authority until the firm's executive committee resolved the matter. Daniel's eyes stopped moving for a moment. It was not a weapon yet, not by itself, but it was the kind of clause that turned private misconduct into institutional risk, and Graham Whitmore was the named managing partner. Daniel lowered the page slowly and looked toward Graham. For the first time since the deposition began, the 2 men shared a silent calculation that Evelyn had once seen during high-stakes trial preparations. It was the look of professionals realizing a narrative might collapse if the wrong door opened. Daniel cleared his throat. He asked when Evelyn had first rediscovered the document. The question itself admitted its significance. Evelyn said she had reviewed the firm's archival governance files several weeks earlier while preparing financial disclosures for the divorce proceedings. Daniel asked whether she believed the clause applied to Graham's personal conduct. Evelyn answered that she believed it applied to conduct involving misuse of firm resources and exposure of the firm to reputational or financial harm. Daniel tapped his pen against the table once, thoughtfully. He knew where the next question had to go. Had Evelyn presented this document to the firm's partnership committee? Evelyn said she had not. The silence in the room deepened, because now everyone understood the implication. If the clause was invoked formally, the issue would move beyond divorce litigation and into firm governance. That meant partners, committees, ethics reviews, financial audits, the kind of institutional attention that elite firms feared far more than public scandal. Daniel spoke carefully now. He asked whether Evelyn intended to use the document as leverage in the divorce settlement. It was a blunt word for a man usually so diplomatic. Evelyn folded her hands again. She said she intended to present the full factual record wherever the law required it to be examined. Across the table, Graham finally shifted. It was a small movement, just enough for Evelyn to notice the way his shoulders straightened slightly, the way his eyes hardened in the particular way they always did when he decided intimidation would be more effective than charm. He spoke directly to her now. He said the clause had been drafted during a transitional restructuring nearly 2 decades earlier. Its purpose had been symbolic reassurance to legacy clients. It had never been used and had no operational authority under the current partnership agreement. Evelyn listened to him the way a surgeon might listen to someone explain anatomy incorrectly. When he finished, she nodded once. Then she removed a second document from the folder and placed it beside the first. The page was newer, much newer, and it contained a signature dated only 4 years earlier, during the firm's last governance revision, confirming that all historical referral clauses remained active unless formally revoked by unanimous partner vote. Daniel Mercer stared at the signature block for a long time before he realized whose signature sat at the bottom of the page. It was Graham's. And for the first time that morning, the man who had planned to dismantle his wife's credibility in a single deposition began to understand that Evelyn had not walked into the room to defend herself. She had walked in holding the legal mechanism that could force his own partners to question whether he still belonged inside the firm bearing his family's name. 4. No one in the room spoke for several seconds after the second document touched the table. It was the kind of silence that did not belong to ordinary conversation. This was institutional silence, the heavy pause that arrived when people who spent their lives navigating risk suddenly recognized a structure beneath them might not be stable. Daniel Mercer read the page again, then a third time. He was not searching for interpretation anymore. He was searching for escape. Lawyers trained at his level did not panic when presented with inconvenient documents. They looked for technical exits, jurisdictional flaws, superseding amendments, procedural limits, something that would reduce the clause from a live mechanism into decorative history. But the signature at the bottom of the page refused to cooperate. 4 years earlier, Whitmore, Reed, and Vail had updated its partnership governance agreement during a firm-wide restructuring. The revision had modernized several operational rules while preserving historical client referral protections that were considered essential to maintaining relationships with Boston's older family trusts. The confirmation page Evelyn had placed on the table was brief and administrative, the sort of page no one studied carefully when signing thick governance packets. Except that the confirmation did something precise. It reaffirmed every legacy appendix, unless those appendices had been specifically revoked by unanimous partner vote. Daniel knew what that meant. The referral trust clause tied to Evelyn's family network had never been revoked, which meant it was still active, which meant the mechanism allowing a trust-originating party to trigger a governance review of a managing partner for misconduct still existed inside the firm's structure. Daniel leaned back slightly, was studying Evelyn in a new way now. Not as a hostile spouse, as a participant in governance. Across the table, Graham had gone completely still again, but this stillness was different from the controlled calm he had worn earlier. That earlier composure had been theatrical confidence. This silence was calculation. Evelyn recognized the shift immediately. Graham had always been dangerous when he felt cornered, not because he lashed out, but because he recalculated power faster than most people in a room. Daniel finally spoke. He asked whether Evelyn had consulted outside counsel about invoking the clause formally. Miriam answered before Evelyn could. She said the question assumed a conclusion that had not yet been reached. At present, they were discussing financial disclosures and marital conduct relevant to the divorce proceedings. However, if evidence indicated firm governance obligations had been triggered, appropriate steps would be considered. Daniel nodded once. The phrasing was careful, but the meaning was obvious. The door existed, and it had not yet been opened. For the first time since the deposition began, Daniel's attention shifted toward Graham with visible concern. It was subtle, the kind of glance most people would miss. But Evelyn had spent 2 decades watching trial teams read each other's thoughts across conference tables. Daniel was silently asking a question. Is there anything else she knows? Graham gave no answer. Instead, he turned back to Evelyn. His voice, when he spoke, was steady but colder now. He said the clause referenced misconduct that endangered the firm. Personal disputes, even unpleasant ones, did not meet that threshold. He suggested that Evelyn's interpretation stretched the language far beyond its intended purpose. Evelyn listened politely, then she reached into the folder again. This time she removed a thinner stack of pages bound by a simple clip. Bank statements, expense authorizations, reimbursement reports. Each document bore the quiet formatting of Whitmore Reed Vail accounting records. Evelyn slid the top page across the table toward Daniel. The entry was small. A dinner charge, $800. The location was a restaurant in Back Bay known for private rooms and discreet service. Daniel glanced at it briefly, clearly unsure why it mattered. Evelyn placed the second page beside it. Another charge, $2,000. The vendor was a Newbury Street boutique. Daniel's eyes flickered once toward the dress Evelyn was wearing. He began to understand. The third document was more specific, a reimbursement request coded under client development expenses. The attached receipt referenced a short-term apartment lease. Daniel's brows lowered slightly. Evelyn allowed a small pause before she spoke again. She explained that each of the charges had been processed through the firm's discretionary expense account, attached to Graham's managing partner privileges. The reimbursements had been approved internally because the accounting codes used for submission implied client-related activity. Daniel studied the documents with growing focus now. This was no longer marital infidelity. This was financial exposure. Graham spoke before Daniel could ask the obvious question. He said client entertainment often involved private locations and hospitality arrangements. It was routine for senior partners to use firm accounts in that manner. Evelyn nodded as though agreeing. Then she slid one final page onto the table. This page was different. It contained a short internal email exchange between Graham and the firm's accounting coordinator. The message referenced a reimbursement delay for the same apartment lease listed earlier. The accounting coordinator had asked for confirmation that the expense related to a client visit. Graham's response was brief. He confirmed the charge fell under business development. There was only one problem. The lease covered 6 months. Daniel stared at the document. Even in Boston's expensive legal culture, 6 months of apartment rent rarely qualified as dinner hospitality. Daniel slowly removed his glasses and cleaned them with a folded handkerchief. It was a small ritual many litigators used when buying themselves time to think. When he looked up again, his tone had changed. He asked Graham directly whether the apartment had been used for client meetings. Graham's jaw tightened almost invisibly. He said it had occasionally been used for professional purposes. Evelyn watched Daniel perform the mental arithmetic she had already completed weeks earlier. If firm funds had supported a private relationship and the charges had been misrepresented as client development expenses, the situation crossed several lines simultaneously. Financial misuse, ethical exposure, reputational risk, exactly the conditions described in the governance clause. Daniel placed the bank statements down very carefully. The deposition room no longer felt like a divorce proceeding. It felt like the first quiet minutes before a much larger investigation. For years, Graham had been the man whose presence steadied Whitmore, Reed, and Vale, the son of the founding partner, the face clients trusted, the managing partner who carried the firm's legacy forward into a modern legal market. Now, a small stack of receipts and an old appendix suggested that the firm's most stable figure might also be its greatest liability. Daniel turned slightly toward Miriam. He asked whether she intended to produce these documents to the firm's partnership committee. Miriam answered calmly that discovery obligations would determine where the materials eventually appeared. Daniel understood the translation. Sooner or later, the partners would see them. Across the table, Graham said nothing, but Evelyn could see the moment his confidence finally fractured. Not loudly, not dramatically, just a thin crack in the armor of a man who had believed he controlled the narrative. Because the story he had prepared for the firm was simple: a difficult divorce, a resentful wife, a manageable settlement. What sat on the table now was something entirely different: a paper trail. And if that trail reached the partnership committee, the question would no longer be about marriage. It would be about whether the Whitmore name still deserved to remain on the firm's front door. 5. The first major shift in the room did not arrive with raised voices or dramatic accusations. It arrived with arithmetic. Daniel Mercer had spent most of his career watching wealthy people believe problems could be dissolved with settlements. Divorce cases in Boston's upper circles rarely ended with public damage because numbers were usually large enough to persuade both sides to stop digging. But Arithmetic worked differently when institutions were involved. Firms did not negotiate with embarrassment the way spouses did. Firms calculated risk. Daniel began flipping through the reimbursement documents again, slower this time, making quiet notes beside the charges. The act looked routine, but the tension in the room tightened around it. Every number he wrote carried a silent implication. How many transactions were there? How long had the pattern existed? Who had approved them? The apartment lease alone represented a 6-month commitment. The boutique purchases, restaurant charges, travel receipts, and reimbursement chains spread across several quarters. None of the amounts individually looked catastrophic. That was precisely what made the pattern dangerous. Institutional fraud rarely began with dramatic theft. It grew through small assumptions that no one would examine closely. Daniel finally spoke again. He asked Evelyn whether she had compiled a full accounting of the charges. Evelyn answered that she had assembled only a preliminary timeline. That was not entirely true. What she had built was far more precise than a timeline. She had mapped the relationship between financial activity and the dates Graham had claimed to be traveling for client meetings. She had cross-referenced those dates with the apartment access logs and internal scheduling memos. But she had learned long ago that revealing too much preparation too early often reduced the impact of the next piece. Daniel asked how many charges she believed were connected to the relationship. Evelyn said she had identified 42 transactions so far. The number landed softly but carried weight. 42 separate uses of firm funds. 42 entries coded as professional expenses. 42 opportunities for the firm's internal accountants to unknowingly certify something that might not survive scrutiny. Across the table, Graham finally moved again. He leaned forward slightly, hands clasped, voice controlled but sharper now. He said that any suggestion of financial misconduct was misleading. Senior partners frequently used firm accounts for hospitality and development purposes that were not easily explained through simple receipts. Client cultivation often required discretion. Evelyn listened with the same patience she once used while editing his trial strategies. Then she turned a single page in the stack. This document was not a receipt. It was a firm calendar entry, a meeting note attached to a client strategy session that Graham had missed nearly 8 months earlier. The note referenced his absence as unavoidable due to a travel commitment in New York with a potential referral client. Evelyn slid a second page beside it, an electronic key log from the Back Bay apartment building. The timestamp placed Graham inside the apartment that same evening. Daniel stared at both pages together. Even in elite litigation, coincidences had limits. The room felt smaller now. Graham said the apartment had occasionally been used for meetings when discretion was necessary. Daniel asked whether any clients had been present during those meetings. Graham hesitated for a fraction of a second too long. That hesitation echoed across the table louder than any accusation. Evelyn noticed Miriam's pen pause. Daniel closed the folder containing the financial records. The expression on his face was no longer the expression of a divorce attorney guiding a difficult case. It was the expression of a man recalculating how much exposure his client might be facing. Because Daniel understood something Graham had not fully grasped yet. If the firm's partnership committee saw even a portion of this material, the issue would move immediately beyond private misconduct. Managing partners were not merely employees, they were fiduciaries. The firm's credibility depended on the belief that their judgment protected both clients and colleagues. Misusing firm funds for a personal relationship was not merely embarrassing. It was a governance problem. Daniel asked one more question, and this time his tone carried careful neutrality. He asked Evelyn whether she had already shared these documents with anyone inside Whitmore, Reed, and Vale. Evelyn folded her hands. She said she had not yet done so. The word "yet" hovered in the room like a suspended object. Graham's voice cut in quickly now. He said the firm's internal procedures would address any accounting irregularities if necessary. There was no need to involve third parties or escalate matters unnecessarily. It was the first moment that sounded almost like a request. Evelyn met his eyes. For 18 years, she had watched him command rooms with practiced authority. Judges, donors, junior attorneys, even clients twice his age had learned to follow the tone he set. Now the tone was shifting, because Graham was no longer arguing about marriage. He was negotiating with the possibility of exposure. Daniel leaned back again, studying Evelyn more carefully than ever. He asked what outcome she expected from presenting these materials. Evelyn answered with the calm clarity that had once made judges lean forward during trial arguments she had written. She said outcomes were determined by facts. The facts suggested that firm resources had supported a concealed relationship. The facts suggested those expenses had been misclassified in internal records. The facts suggested the firm's managing partner had personally authorized those reimbursements. She paused briefly before adding the final piece. And the facts suggested that the firm's governance documents required review if such conduct created reputational or financial risk. Daniel did not respond immediately. Instead, he looked toward Graham again, silently asking the question every attorney eventually asks when a case begins slipping away from the script. Is there anything else she might find? Graham said nothing, but the silence was answer enough, because Evelyn knew the arithmetic had only just begun. And once partners at Whitmore, Reed & Vale started calculating risk, the next conversation would not be about protecting Graham Whitmore. It would be about protecting the firm from him. 6. By the time the deposition paused for its scheduled break, the room no longer belonged to Graham. Nothing dramatic had happened in the theatrical sense. No one had slammed a folder shut. No one had raised their voice. But the balance of gravity had shifted so completely that even the quiet rituals of litigation, pouring water, checking phones, stepping into the hallway, felt different. Daniel Mercer was the first to stand. He gathered the financial documents with more care than necessary, stacking them slowly as though the extra seconds might give him time to reorganize the narrative he had arrived with that morning. The narrative had been simple: an ambitious husband, a resentful wife, a settlement to be negotiated efficiently. Now the story had mutated into something far less manageable. Daniel turned to Graham. They did not speak at first. Lawyers trained in elite firms learned early that many conversations happened without words. A glance could carry questions no one wanted recorded. A tightened jaw could confirm an answer. Evelyn watched the exchange from across the table. For years, she had studied that silent language during trial preparation sessions, when Graham and his father would confer across documents with the quiet intensity of men accustomed to winning. The pattern was familiar: assess damage, identify exposure, decide whether to fight or contain. Daniel finally spoke in a low voice. He suggested they step into the hallway. Graham stood without looking at Evelyn. The two men walked out together, the conference room door closing softly behind them. The moment the latch clicked, the tension that had been compressing the room released just enough for people to breathe again. The court reporter removed her glasses and rubbed the bridge of her nose. Miriam leaned slightly toward Evelyn, not speaking yet, but studying her client with an expression that mixed admiration and professional concern. Evelyn poured herself a small glass of water. Her hands were steady. That steadiness surprised Miriam more than anything else, because most people who detonated this kind of institutional problem did so in anger. They came to the moment already exhausted from the emotional war that preceded it. But Evelyn had arrived with something colder than anger: preparation. Miriam finally spoke quietly. She asked how long Evelyn had been collecting the documents. Evelyn answered that the review had begun about 3 weeks earlier. Miriam exhaled slowly. 3 weeks was not long in legal terms, yet the file on the table suggested something far more deliberate than a hurried discovery. Miriam had handled enough high-net-worth divorces to recognize the difference between suspicion and investigation. This had been an investigation. In the hallway outside, voices murmured faintly through the door. Daniel's tone was controlled but urgent. Graham's voice was lower, harder to distinguish. Evelyn did not try to listen. She already knew what they were discussing. Daniel would be explaining the exposure in blunt terms. If the financial pattern Evelyn had outlined appeared in discovery filings, opposing counsel could argue misuse of firm funds. If the governance clause was triggered, the partnership committee would be required to review Graham's conduct. That review alone could destabilize the firm's leadership structure, and the timing could not be worse. Whitmore, Reed & Vale had recently expanded its litigation division and taken on several high-profile family wealth clients. Stability at the top of the firm mattered. If the managing partner suddenly became the center of an ethical investigation, the reputational damage could spread quickly. Daniel would be asking Graham the question Evelyn had already answered for herself weeks ago. Is there anything else she could find? The door opened again after several minutes. Graham returned first. The composure he wore now looked carefully rebuilt, like a structure repaired after the first tremor of an earthquake. Daniel followed him, expression controlled but noticeably tighter around the eyes. Everyone took their seats again. Daniel adjusted the stack of documents in front of him. When he spoke this time, the tone of the deposition had changed. He was no longer trying to undermine Evelyn's credibility. Instead, he began asking questions that sounded procedural but carried deeper intent. Had Evelyn reviewed all reimbursement categories linked to Graham's discretionary account? Had she identified any transactions involving direct transfers to individuals? Had she encountered any communications suggesting that firm personnel were aware of the apartment arrangement? Each question revealed something important. Daniel was no longer defending the narrative Graham had brought into the room. He was mapping the perimeter of the problem. Evelyn answered carefully, never exaggerating. She said the preliminary review focused primarily on expense reimbursements rather than internal communications. She had not yet conducted a full audit of the firm's accounting systems. Daniel nodded slowly. The phrase "not yet" appeared again. Across the table, Graham's expression hardened. For the first time that morning, he spoke directly to Evelyn without attempting to soften his tone. He said that escalating a personal matter into firm governance proceedings would damage far more people than it protected. Clients relied on stability. The firm's employees depended on its reputation. Turning private conflict into institutional crisis would create consequences that could not be easily undone. It was the closest he had come to anger. Evelyn met his gaze calmly. She said the consequences had begun the moment firm accounts were used to support a hidden relationship. The room fell silent again, because everyone present understood the implication. The crisis Graham feared had not been created by Evelyn. It had been created by his own decisions. Daniel leaned forward, folding his hands. He asked one final question before the break ended. If the firm's partnership committee requested the documents she had collected, would Evelyn provide them? The question sounded neutral, but the entire deposition now revolved around the answer. Evelyn did not hesitate. She said she would comply with any lawful request for documentation relevant to governance obligations. Daniel closed his notebook slowly. The deposition could continue for hours, but the real event had already happened. The story Graham had planned for this morning, a disciplined husband confronting an unreasonable spouse, had collapsed under the weight of a few quiet pages. In its place stood a far more dangerous narrative. The managing partner of Whitmore, Reed & Vale might have violated the very governance structure designed to protect the firm. And the only person who possessed the documents capable of triggering that review was the woman he had intended to leave with nothing. Across the table, Graham finally understood the full shape of the disaster forming around him. because if Evelyn chose to open the next door, the next people asking questions would not be divorce lawyers. They would be his own partners. 7. The deposition resumed after the break with a faint tension in the air, like a storm that had paused for a moment, only to gather even more force. Daniel Mercer returned to his chair first, the weight of what he had already seen pressing against him. Graham followed, carefully adjusting his jacket, but the tightness in his jaw betrayed him. He had spent a lifetime managing appearances, but appearances could only carry a person so far when documents were stacked neatly before an audience who had suddenly recognized the hidden leverage. Evelyn remained composed, her hands folded lightly over the leather folder. The dress she wore, intended for another woman, now seemed to serve as a quiet declaration. She was no longer the invisible partner behind the scenes. She was present. She was prepared. She was, in the most literal sense, untouchable. Daniel began the next round of questioning with subtle precision. He asked Evelyn about her interactions with the firm's accounting department. Had she ever discussed reimbursements? Not for personal clarification, he meant in any formal capacity. Evelyn's answers were careful, deliberate, but revealing in the way only someone intimately familiar with both the rules and the practice of omission could manage. She described routine oversight that Graham had delegated casually, how certain approvals had passed under his signature but without her needing to intervene, and how she had noticed discrepancies only when cross-referencing dates and client records for her own purposes. Each answer planted seeds of doubt in Graham's mind. Small, almost invisible at first, but persistent. A partner might dismiss minor irregularities, but a managing partner? Anything appearing systemic would demand scrutiny. And now those seeds had been watered by weeks of Evelyn's meticulous preparation. Daniel shifted focus. He asked for specifics, dates, amounts, and context, drawing Evelyn into a factual narrative that looked harmless on the surface, but, piece by piece, constructed a lattice of evidence linking personal misconduct to potential firm exposure. Each time she referenced a transaction, a date, or a memo, she did so with precision, not an accusation, not in anger, just facts. Facts that the firm could not ignore. Graham's hands flexed on the table. He had spent 18 years assuming that the personal and professional spheres were separate enough that minor lapses would never threaten the edifice he had built. Now, those spheres were intersecting, and the foundation trembled. Miriam Sloan leaned in slightly toward Evelyn, a silent nod of approval. The lawyer's years of courtroom experience told her that the most dangerous testimony is delivered without theatrics. Evelyn had mastered that art, and it was beginning to fracture the confidence of the men around her. Daniel, sensing the shift, paused for a moment, the rhythm of his questioning broken. He had entered the deposition expecting a manageable spouse, someone to be guided, contained, and subtly undermined. Instead, he faced a woman orchestrating her narrative with surgical precision. He understood that any misstep in phrasing could escalate the situation far beyond ordinary divorce proceedings. The weight of potential governance consequences now hovered silently over the table. Graham, sensing the room's recalibration, attempted to reclaim control. He reminded everyone that firm accounts were often used for legitimate client development and entertainment. He emphasized discretion, professionalism, and the importance of avoiding public scrutiny. His voice was calm, but Evelyn could detect the tension behind it, the recognition that facts now outweighed his carefully rehearsed narrative. Evelyn's response was measured. She did not challenge him emotionally. She did not raise her voice. She simply pointed out the discrepancies between approved reimbursements and actual usage, presenting the dates, the amounts, and the context as if reading a ledger aloud. Each fact landed with precision, building a case that could not be dismissed as misunderstanding or emotion. A quiet acknowledgement passed between Daniel and Miriam. They both understood the implications. The deposition had evolved from a personal confrontation to a matter that could trigger an institutional review. the firm's governance documents, Evelyn's archival research, and the evidence of financial misclassification had converged to create a scenario Graham had never anticipated. Graham's expression remained calm on the surface, but Evelyn could see the subtle signs: the tightening of his lips, the flicker of uncertainty in his eyes, the barely perceptible clench of his fists. The man who had once commanded rooms effortlessly now found himself navigating unfamiliar territory, a room where the quietest presence carried the heaviest weight. And in that moment, Evelyn realized something profound. The deposition was not merely about reclaiming her rights in a divorce. It was about revealing the fragile architecture of power that had always depended on others' labor, discretion, and silence, and she held the evidence to expose it. Her fingers rested lightly on the folder, but inside, the next revelation waited. One more layer of proof, one more document, one more carefully crafted connection, and the narrative could shift irrevocably. The room had already begun to acknowledge the change, even before she decided to push further, because sometimes in high-stakes Boston litigation, the quietest hand at the table is the one that moves first. And Evelyn's hand was ready. 8. When the court reporter's pen paused mid-line to capture a procedural note, Evelyn felt the subtle shift in energy across the room. What had started as a routine deposition for a divorce had transformed into something larger, something Graham Whitmore had not anticipated, and something Daniel Mercer, despite years of experience, could not fully contain. The documents lay between them like a bridge to a new reality. Numbers, dates, and clauses arranged so precisely that the room itself seemed to lean forward in anticipation. Graham adjusted his seat slightly, a habitual move he had perfected over decades to signal confidence while secretly recalculating. His eyes darted once to the folder in front of Evelyn, then back to Daniel, searching for reassurance he could not find. Every subtle sign betrayed the unease of a man suddenly aware that the foundation of his authority was no longer unquestionable. He had spent years assuming that his personal missteps would remain private, contained within the realm of marriage. Now, those missteps threatened not just his personal reputation, but the very firm he had thought untouchable. Daniel Mercer, however, was still operating with caution. Lawyers like him understood the difference between emotion and leverage. He had seen countless high-profile spouses attempt dramatic displays, only to falter when real documents were introduced. But Evelyn was different. Her approach was meticulous, understated, and devastatingly effective. Each fact she presented was a calculated move, a quiet assertion of authority that Graham had failed to recognize until now. Evelyn began to summarize her findings with clinical clarity, tracing the pattern of firm funds used for personal benefit while under the guise of professional development. Each example was precise, verifiable, and aligned chronologically with internal firm memos, expense reports, and travel logs. She did not speak with anger or accusation, only with the measured certainty of someone who knew the truth and understood its power. Daniel interjected at one point, asking about any communications she might have encountered regarding the apartment or related expenses. Evelyn produced a succinct series of emails showing the chain of approvals, confirmations, and justifications, all meticulously preserved. The evidence was now undeniable. The quietest documents had spoken the loudest. Graham's calm began to fray at the edges. The lines of his face hardened as he tried to process the implications. Each page, Evelyn revealed, eroded the narrative he had relied upon for years. That his personal indiscretions were contained, his financial authority secure, and his position at the firm untouchable. Every document she presented contradicted that illusion. The tension in the room grew heavier as Evelyn opened the next folder, revealing correspondence that directly tied Graham's discretionary approvals to personal activities that fell outside professional parameters. Daniel's pen hovered, the scribbled notes now shifting from potential defense strategies to problem recognition. The The partnership, the firm's ethics, and Graham's own position were all now intertwined with the documents Evelyn held. Evelyn paused for effect, placing her hands calmly atop the folder. No one needed to speak. The room collectively understood that the power dynamics had irrevocably changed. Graham's once unquestioned authority was now vulnerable to scrutiny by the very institution he had dominated. And in that silence, Evelyn realized the next step was no longer about confrontation. It was about initiation. The documents were no longer just evidence. They were instruments of structural accountability, poised to transform personal betrayal into institutional reckoning. Graham's hands clenched slightly on the table, a subtle but telling gesture. His mind raced, calculating damage control and potential defenses. But Evelyn had already calculated the path of exposure, the precise conditions under which the partnership committee could be compelled to act. Every legal contingency, every procedural nuance had been anticipated and laid out. She leaned back slightly, letting the weight of the moment settle. The room was tense, the air charged, but Evelyn felt a quiet satisfaction. Not vengeance, not drama, but clarity. She had turned 18 years of invisible labor, overlooked strategy, and meticulous attention into leverage that could not be ignored. And now, she was ready to move to the next step, the one that would ensure the truth of her influence and the consequences of Graham's decisions reached the right ears at Whitmore, Reed, and Vale. Because in Boston's elite legal circles, power was rarely about who shouted the loudest. It was about who held the evidence, who understood the rules, and who had the patience to wait until the world leaned forward to listen. Evelyn's hand rested lightly on the folder, and the next revelation waited, patient and inevitable. 9. When the deposition reconvened after the brief pause, Evelyn noticed subtle changes in body language around the table. Daniel Mercer's posture was more guarded, less conversational. He had spent decades observing elite spouses, predicting reactions, controlling the narrative. But here, he found himself recalibrating with every precise fact Evelyn presented. Graham Whitmore's shoulders were rigid now, his voice clipped whenever he spoke, that betraying the calm authority he had relied upon for years. The veneer of control was cracking, almost imperceptibly yet unmistakably. Evelyn began the next phase of her presentation. She introduced a series of meticulously compiled charts, cross-referencing reimbursement entries with dates of claimed client meetings. Each line item was precise: a restaurant dinner tagged as client entertainment, a Back Bay boutique charge coded under business development, the apartment lease noted as occasional client use. Individually, none of these would have seemed extraordinary. Together, however, they revealed a pattern of misrepresentation that was difficult to dismiss. Daniel leaned in closer, pen poised but his expression tight. He was no longer guiding the deposition, he was evaluating exposure. Every document Evelyn produced, every date she highlighted, chipped away at the comfortable assumptions that Graham had relied upon. She did not speak with anger or accusation. She merely presented facts, letting their clarity and inevitability carry the weight. Graham cleared his throat and attempted to interject, emphasizing the ordinary nature of client development expenses. But the words sounded hollow even to his own ears. Evelyn's calm, methodical pacing left little room for interruption. Each counterpoint he made was already anticipated by the evidence before him. Evelyn allowed herself a subtle moment of satisfaction as she referenced the internal approval emails that confirmed Graham had authorized the expenditures personally. The correspondence was polite, professional in tone, but unmistakably tied to personal activities rather than legitimate business development. She did not need to elaborate. The documents spoke for themselves. The room was quiet, the kind of quiet that comes when control has shifted imperceptibly, yet irrevocably. The court reporter typed steadily, capturing every word, but the real story was in the unspoken understanding now spreading across the table. Graham's authority, once absolute in the firm's corridors, had been replaced by exposure. Daniel Mercer's focus had shifted entirely to damage assessment. Miriam Sloan leaned slightly toward Evelyn, a faint nod acknowledging the precision with which her client navigated the terrain. Evelyn had transformed years of overlooked labor into leverage that could not be ignored. The weight of institutional consequences hung in the air, yet she maintained perfect composure. Then, almost casually, Evelyn opened the next section of her folder, a series of financial reconciliations tied directly to firm partners who had unwittingly reinforced Graham's privileges. The pages revealed a network of approvals and omissions, all pointing to a pattern of vulnerability in firm governance. Daniel's eyes flicked from page to page, realizing that if these documents reached the partnership committee, the implications would extend far beyond personal divorce proceedings. Graham's hand twitched slightly on the table. He had underestimated the meticulousness of the woman he had intended to marginalize. For the first time that morning, he felt exposed not just personally, but professionally. Evelyn rested her hands lightly on the folder. The next revelation, the one that would fully translate her years of hidden work into undeniable authority, was within reach. She did not rush. She waited, allowing the silence, the tension, and the anticipation to set the stage. Because in Boston's elite legal circles, patience often outweighed passion, and Evelyn had spent 18 years mastering both. The room leaned forward, even though no one realized it yet, and Evelyn knew that when she revealed the next layer, the foundation Graham had relied upon for decades would begin to tremble. The subtle tremor of authority in the room became more pronounced as Evelyn prepared to introduce the next piece of evidence. It was a quiet weapon, no shouting, no theatrics, just documents that traced the exact chain of discretionary approvals Graham had made over the years. Each page mapped a pattern of personal indulgence hidden beneath the guise of professional necessity, and each line was verified with timestamps, email headers, and internal ledger codes. The arithmetic of misconduct had begun to speak louder than any accusation. Daniel leaned back slightly, processing the implications. His carefully crafted deposition strategy, built on assumptions of a compliant peripheral spouse, was dissolving under the weight of precision. Every fact Evelyn presented undermined the narrative he had expected to control. He was forced to recalibrate, turning from interrogator to analyst, and the change was visible in the tightening of his jaw, the slight narrowing of his eyes, the way his fingers drummed hesitantly on the polished table. Graham's composure was beginning to crumble in subtle ways Evelyn could detect with surgical clarity. He attempted the familiar rhetoric of precedent and client development, but it rang hollow. The room had shifted from a routine marital deposition to a quasi-institutional audit, and the man who had believed his discretion was absolute was confronted with proof that it was now conditional, contingent upon others' interpretations, and dangerously exposed. Evelyn introduced the next sequence, a ledger of recurring expenses linked to personal interactions disguised as client meetings, each cross-referenced with internal approvals and reconciliations. The pattern was undeniable, almost mechanical in its repetition. Daniel's pen moved quickly, scribbling notes, yet every line seemed to cement the emerging reality. If these documents reached the partnership committee, Graham's judgment, integrity, and continued authority as managing partner would be questioned, perhaps irreversibly. Graham's lips pressed into a thin line, the only outward manifestation of internal panic. He had orchestrated a life and career around appearances, carefully engineering every perception. Yet here, in a conference room lined with muted art and polished wood, appearances meant nothing against the silent authority of verifiable documentation. Evelyn paused, placing her hands deliberately atop the folder. The gesture was casual, almost indifferent, yet it radiated control. She did not speak, allowing Daniel and Graham to absorb the implications of what had already been revealed. Silence, Evelyn knew, was a tool often more powerful than argument. It forced the room to reckon with truths that could not be disputed and circumstances that could not be ignored. Then, with a subtle shift, Evelyn slid forward a final series of pages. Internal communications between Graham and the accounting team regarding approvals of expenses, now clearly personal. The emails, professional in tone but revealing in content, left no ambiguity. Each one tied the discretionary privileges of a managing partner to activities outside legitimate firm business. The evidence was irrefutable, and the consequences potentially seismic. Daniel's pen paused mid-note. He had handled many high-stakes depositions, but the combination of clarity, precision, and unassuming authority Evelyn exhibited was uncommon. He realized that every miscalculation, every assumption Graham had made about his wife's passivity had left him vulnerable. Graham's face hardened as the weight of institutional exposure settled over him. He had anticipated marital tension, perhaps public embarrassment, but never scrutiny that could endanger the very leadership position he had long taken for granted. Evelyn leaned back slightly, the folder resting lightly before her, each page a calculated instrument. The deposition was no longer about divorce. It was about accountability, governance, and the quiet realization that the woman once presumed invisible now controlled the narrative, and she was just beginning to reveal the extent of her leverage. The first major climax of truth had been set into motion. Because in Boston law, facts never lie, but people who ignore them often fall. The next revelation, waiting in the folder, promised to make that fall unavoidable. 11. Evelyn could feel the subtle shift in the room as Daniel Mercer adjusted his notes and Graham Whitmore's posture stiffened, the old confidence replaced by a taut tension that seemed to radiate from his very shoulders. The quiet arithmetic of misused funds and documented approvals had done more damage than any public confrontation ever could. What remained now was the demonstration of intent, the articulation of a pattern that no one could argue was incidental. She opened another section of her folder, revealing internal correspondence between Graham and several junior associates. The emails were routine in tone, professional, almost innocuous, but the content mapped a pattern of preferential treatment and deliberate concealment. Requests for reimbursement, approvals for off-site accommodations, and scheduling notes all pointed to a repeated use of firm resources for personal purposes. Individually, each email could be rationalized. Collectively, they formed a narrative of calculated disregard for firm governance. Daniel leaned in, his pen hovering over the pad, recognizing the implications. This was no longer about marital discord. It was about governance exposure, fiduciary responsibility, and the delicate reputation of Whitmore Reed and Vale. Every careful assumption Graham had made that the personal and the professional could remain separate was being dismantled in measured, methodical strokes. Graham's fingers drummed lightly on the polished wood, a subtle outward expression of internal calculation. He had spent years orchestrating appearances, managing partners, and building an untouchable facade. Yet here, each page, each email, each ledger entry chipped away at that structure. Even his well-practiced calm could not hide the fact that the institution he had believed secure now faced potential scrutiny, triggered by actions he thought private. Evelyn's delivery was precise. She did not scold, accuse, or plead. She simply laid out facts, dates, and documents in a sequence that allowed the logic to speak for itself. She highlighted patterns without commentary, letting the evidence create the narrative. The arithmetic of exposure was evident, and she had arranged it so meticulously that denial would appear irrational. Daniel's attention had shifted entirely to Graham. He no longer needed to interrogate Evelyn for credibility. Her preparation, composure, and evidence had established it beyond question. Now he was calculating the potential fallout, the risk to the firm, the partners, the fiduciary obligations, and the inevitable questions that would arise when these findings reached the partnership committee. Graham, sensing the quiet but relentless pressure, attempted a measured defense. He spoke of discretion, client development, and the occasional necessity of flexible accounting for high-level business dealings. Yet each claim faltered under the weight of Evelyn's documented evidence, every justification constrained by dates, approvals, and the previously ignored governance clauses she had unearthed. Miriam Sloan, sitting quietly beside Evelyn, allowed a faint nod, a recognition that her client had shifted the balance of power completely. For the first time in the deposition, it was clear that Evelyn was in command. Her years of invisible work had been transformed into undeniable leverage, and every subtle gesture now reinforced her position. Evelyn reached for another page, a calculated pause signaling the transition to the final part of her preliminary reveal. This section contained a reconciliation of all identified discrepancies, correlating financial approvals with personal use. The pattern was undeniable. Misuse of firm resources, approval chains, and internal acknowledgement of such activities all converged into a narrative Graham could not control. She slid the page forward deliberately. Silence fell again. The room was no longer just attentive, it was holding its collective breath. Graham's usual strategy of quiet intimidation had failed, and Daniel Mercer had begun recalculating options he hadn't considered before the deposition began. And Evelyn, poised, composed, and unflinching, allowed the room to absorb the consequences. The first wave of institutional reckoning had been unleashed. The next layer, waiting in the final pages of the folder, promised to turn calculated exposure into undeniable authority, one that Graham could neither mitigate nor ignore. 12. Evelyn's eyes swept the table as she prepared the next set of pages. Careful, deliberate, as though every movement was part of a larger choreography. This section of the folder contained internal firm memos and meeting notes that traced patterns of approvals, exceptions, and informal authorizations made by Graham over the last several years. Individually, they might have seemed mundane, mere administrative minutiae, but together they painted a clear picture. A managing partner repeatedly exercising discretion in ways that blurred the lines between professional responsibility and personal convenience. Daniel Mercer studied the documents with a tightening expression. He had been in countless depositions, navigating the delicate balance between marital negotiation and institutional exposure, but the precision here was extraordinary. Each page, Evelyn revealed, demonstrated not just oversight, but the consequence of repeated choice, a pattern he knew could not be ignored if it reached the partnership committee. Graham's posture, previously disciplined, began to betray micro-expressions of anxiety. His lips pressed tighter, his gaze flicked toward the folder more frequently, and his fingers flexed almost imperceptibly against the polished wood. He had assumed his discretion was untouchable, his authority unquestionable, but Evelyn had dismantled that assumption with quiet clinical precision. Evelyn did not speak immediately. She allowed the documents to carry the weight of the narrative. Every line, every notation, every internal email reinforced a story Graham had hoped would remain invisible. She had transformed 18 years of invisible labor into undeniable evidence. The calmness in her demeanor magnified the potency of the files before them. Daniel's voice finally cut through the silence. He asked Evelyn to clarify her process in assembling these documents, how she had verified dates, approvals, and corresponding expenditures. Evelyn responded methodically, describing her meticulous cross-referencing of ledgers, correspondence, and approval chains. Each answer reinforced her credibility, while emphasizing Graham's direct responsibility in authorizing transactions that now clearly breached firm protocol. Graham opened his mouth to respond, to explain away the discrepancies, but Evelyn anticipated every justification. She slid a new page forward, this one showing a cumulative summary of discretionary approvals directly linked to personal expenses. The total amount was not staggering by Boston standards, but the pattern, the intent, and the concealment were what mattered. Daniel's pen paused mid-note. He glanced at Graham, then back at Evelyn. recognizing that the deposition had evolved into something beyond a divorce negotiation. This was no longer about dividing assets or establishing spousal entitlement. This was about governance, fiduciary oversight, and institutional accountability. Graham's voice, when it finally came, was tight and calculated. He emphasized that the firm's discretion policies allowed for flexible use of resources and that any perceived misuse was unintentional. But Evelyn's next move neutralized that defense. She presented an email chain where Graham had explicitly approved certain expenses under the guise of client development, while knowing the charges were linked to personal engagements. The subtle, precise documentation left no room for plausible deniability. Miriam Sloane, observing quietly, allowed a faint smile. The strategy was working. Evelyn had never needed theatrics. The combination of thorough preparation, patience, and quiet authority was dismantling Graham's assumed control piece by piece. The room remained tense, every participant acutely aware that the next step could shift the balance irreversibly. Evelyn's hand rested lightly on the folder. She had reached the critical juncture. One final set of documents remained, the evidence that would transform the preliminary exposure into undeniable leverage. And when she revealed them, the deposition would no longer be a routine exercise in protocol. It would become the moment the firm and Graham understood who truly held authority. 13. Evelyn allowed herself a small, deliberate pause before opening the next section of the folder. These were the documents she had saved for this moment. Emails, ledger reconciliations, and annotated approvals that directly connected Graham's discretionary authority to repeated personal expenditures. They were unassuming at first glance, rows of numbers, brief messages, but together they formed a lattice of evidence no lawyer could ignore. Daniel Mercer adjusted in his seat, now fully attentive. The careful strategy he had brought to the deposition, the calm guidance of a predictable narrative, was unraveling. He realized that Evelyn was not just defending herself, she was constructing an irrefutable sequence of proof that mapped behavior, intent, and the resulting institutional risk. Every notation reinforced the same conclusion. Graham's discretion had been repeatedly exercised to conceal personal activity using firm resources, and the potential consequences extended far beyond a marital settlement. Graham's posture stiffened as he recognized the significance. His voice, measured but strained, attempted to rationalize the activity. Discretionary accounts, client development, occasional exceptions. He had relied on the assumption that small patterns would go unnoticed, that no one would cross-reference dates, approvals, and internal memos with such precision. Evelyn had dismantled that assumption quietly but completely. She began presenting the documents systematically. Each page tied a particular reimbursement to a personal engagement, with corroborating internal approvals and email threads that clearly indicated knowledge within the firm's accounting hierarchy. She didn't dramatize, didn't raise her voice. She let the evidence speak, methodically establishing a chain of authority, accountability, and exposure. Daniel leaned forward, pen hovering. The first time in the morning, his attention had left merely observing and entered full analytical mode. He realized that this deposition had shifted into uncharted territory, the intersection of private misconduct, fiduciary responsibility, and institutional governance. Every new page Evelyn revealed tightened the net around Graham. Graham, sensing the inexorability of the exposure, attempted a controlled defense. He emphasized discretion policies, client development needs, and the usual ambiguity in high-level accounting. But Evelyn countered without words, simply laying out the emails, approvals, and reconciliations that left little room for interpretation. The precision of her presentation made the defense almost irrelevant. Miriam Sloane, seated beside Evelyn, allowed herself a quiet nod. Evelyn had transformed years of invisible labor, quiet corrections, and meticulous oversight into undeniable leverage. No one in the room could question the authenticity of the documentation, nor could they ignore the implications. Evelyn paused again, placing her hand on the top page of the next set. These were the final documents in her preliminary reveal. The reconciliations tying every identified expense, authorization, and communication directly to Graham's discretion. Every line item was verified, cross-referenced, and contextualized to expose the full pattern. The room held its collective breath. Graham's face remained composed outwardly, but the tension was unmistakable. Daniel's pen was frozen mid-note. Even the court reporter seemed to slow, as if sensing that the deposition had moved beyond ordinary proceedings. Evelyn's voice finally broke the silence, calm, precise, and unavoidable. She indicated that these documents demonstrated consistent patterns of personal expenditure approved under the guise of professional necessity. Each pattern aligned with the governance clause she had revealed earlier, making the matter not just a personal dispute, but a potential institutional concern. The subtle shift was complete. The first major wave of exposure had landed. Graham could no longer rely on assumptions, charm, or control over appearances. Evelyn had quietly, methodically, and irreversibly taken the power into her own hands. And the next step, the full demonstration of how her authority could compel institutional action, was waiting in the final layer of the folder, ready to transform the deposition from revelation into irrevocable consequence. 14. The room grew heavier as Evelyn reached for the last set of documents in the folder. These were not merely ledgers or emails. They were the culmination of 18 years of work no one had ever noticed. Every annotation, every cross-reference, every careful notation pointed to a single, undeniable truth. She had been the architect behind the very structure Graham had assumed was solely his. She had built the scaffolding, maintained the foundations, and now held the keys to unlock the doors he believed impenetrable. Daniel Mercer's pen hovered uncertainly over his pad. He had faced difficult depositions before, but never one orchestrated with such quiet authority. Evelyn's methodical pacing, her calm precision, and the clarity of her evidence had shifted the deposition from a simple marital inquiry into an institutional reckoning. He understood fully now that if these final documents were examined by the firm's partners, the consequences could be seismic. Graham's fingers drummed lightly on the table, betraying a tension he could not suppress. Every detail Evelyn had revealed, the reimbursement patterns, the approvals, the internal correspondence, was now reinforced by the final batch of reconciliations. They showed cumulative exposure, repeated discretionary approvals directly tied to personal benefit, correlated with internal knowledge and timestamps. Individually, any page might have seemed trivial. Together, they constructed a lattice of accountability that Graham could neither explain away nor dismiss. Evelyn presented the first page with deliberate care, sliding it slowly across the table. It contained a chronological summary of expenses linked to discretionary approvals, clearly highlighting recurring patterns. Daniel's eyes flicked from the document to Graham, realizing the implications before Graham did. The room was tense, the subtle energy of authority shifting visibly toward Evelyn. She followed with supporting documentation, emails where Graham himself had confirmed approvals, internal accounting notes, and memos showing acknowledgement by associates who processed these transactions. The precision was quiet, almost clinical, but its impact was undeniable. Each piece corroborated the next, creating a web of evidence that left no room for plausible deniability. Graham attempted a measured response. He spoke of routine client development, discretion in senior partner accounts, and occasional oversights. But Evelyn anticipated every argument. Without raising her voice or showing anger, she highlighted inconsistencies between claimed client-related activity and actual documented use. Each subtle contradiction chipped away at the facade he had maintained for decades. Miriam Sloan, observing beside Evelyn, allowed herself a faint nod. Evelyn's strategy was unfolding perfectly. She had transformed invisible labor and meticulous preparation into tangible leverage. The room now acknowledged, without words that the balance of authority had shifted irrevocably. Evelyn paused, letting the weight of the documents and the implications settle. Daniel Mercer's notes had slowed, his analytical mind now focused entirely on the emerging exposure. Graham's composure had hardened, but the subtle cracks in his authority were unmistakable. Finally, Evelyn spoke, calm and deliberate. She reminded everyone that these documents, combined with the governance clause she had revealed earlier, positioned her not as a mere participant in the firm's history, but as a stakeholder with the authority to compel institutional review if misconduct persisted. The deposition was no longer about a marital dispute. It had become a quiet, methodical demonstration of power, authority, and accountability. The room understood it. Graham understood it. And Evelyn, poised and composed, knew that the true reckoning was only beginning. The stage was set. The partners would soon see the documents, the consequences would unfold, and Evelyn held the moment and the power in her hands. 15. The second major wave of tension began the moment the folder's final documents settled on the table. For years, Graham Whitmore had believed that his authority, carefully maintained behind polished appearances and cultivated deference, was untouchable. But now every page Evelyn had prepared, every email, ledger entry, and internal memo converged to reveal a pattern of discretion used for personal benefit, a subtle but unmistakable breach of governance. The quiet arithmetic of misuse was devastating precisely because it was cumulative, systematic, and indisputable. Daniel Mercer, normally composed and calculating, leaned back and rubbed the bridge of his nose. He realized that the deposition had shifted from marital negotiation to a potential institutional crisis. The firm's governance clauses, combined with the evidence Evelyn had meticulously assembled, left Graham exposed in ways he had never anticipated. Every standard strategy he could have employed to protect himself was now compromised. Graham, aware of the stakes for the first time, tried to assert control. His voice was steady, measured, but the underlying tension betrayed him. He spoke of client development, routine discretion, and the occasional necessity of flexible accounting. But the words sounded hollow against the weight of Evelyn's evidence. The documents she presented were not subjective. They were traceable, verifiable, and legally significant. Evelyn, seated with the calm precision that had carried her through years of invisible labor, allowed the documents to do the work. Each page revealed approvals for expenditures that were misrepresented as client-related. Each email tied Graham directly to the decisions, and each memo confirmed internal awareness. She spoke only when necessary, her voice steady, her tone neutral, letting the weight of the facts speak louder than argument or emotion ever could. Daniel's pen moved again, slower this time, as he tried to reconcile the implications. The cumulative evidence suggested not just personal misconduct, but potential violations of fiduciary duty. If these findings reached the partnership committee, the governing clause Evelyn had revealed could trigger a formal review of Graham's role as managing partner. The very institution he had relied upon for authority was now a potential instrument of accountability. Graham's hands flexed slightly on the table. He had underestimated Evelyn's preparation, her methodical approach, and her understanding of institutional law. He realized in a flash that his decades of control over appearances and partnerships could be undone by the quiet, precise work of the woman he had intended to marginalize. Miriam Sloan leaned subtly toward Evelyn, acknowledging the brilliance of her client's strategy. Evelyn had taken years of overlooked labor, drafting strategies, reviewing documents, guiding operations from the shadows, and transformed them into leverage no one could ignore. She was no longer simply a party to the divorce. She had become the catalyst for a possible institutional review. The holder of authority Graham had assumed was solely his. The room was silent, save for the soft tapping of Daniel's pen and the faint shuffle of paper. Every participant understood the magnitude of what was unfolding. The deposition had transcended personal dispute and entered the realm of firm governance and accountability. Evelyn rested her hands lightly on the folder. The first major climax, the revelation of personal and financial exposure tied to institutional risk, was complete. The next step, the full demonstration of her leverage over Graham and the firm, was poised to redefine the balance of power entirely, and in that stillness, every subtle signal in the room acknowledged it. The woman they had underestimated was now in command. 16. The room seemed to shrink under the weight of realization. Graham Whitmore had spent a lifetime believing he could control outcomes, manipulate perceptions, and contain risks, both personal and professional. But the evidence Evelyn had methodically laid before him had undone that illusion with surgical precision. What had been a routine deposition for a divorce had transformed into the first stage of institutional reckoning. Every ledger entry, email, and internal memo she presented illustrated a pattern of discretion misused, discretion that had previously been invisible, unquestioned, and assumed safe. Daniel Mercer, for the first time that morning, seemed genuinely unsettled. His pen, which had been moving confidently throughout the deposition, now hovered indecisively above his notes. He understood the implications. This was no longer a matter of negotiating spousal settlements. The governance clause Evelyn had uncovered, combined with her meticulous documentation, meant that the firm itself could be forced into action. Graham's position as managing partner, once untouchable, was now under immediate, undeniable threat. Graham's hands gripped the edge of the table tightly, knuckles white beneath his calm exterior. He had relied on assumptions of loyalty, discretion, and invisibility, all of which Evelyn had systematically dismantled. His carefully rehearsed explanations of client development and discretionary spending rang hollow against the clear, chronological, and cross-referenced evidence she had provided. Each fact chipped away at the fortress of authority he had built over decades. Evelyn leaned back slightly, letting the silence press on the men across the table. She did not speak with accusation or drama. She merely allowed the documents, the evidence, and her calm presence to convey the message. The balance of power had shifted, and she now held the tools to enforce accountability. She gestured ever so slightly toward the final page in her folder. This one was the culmination of her careful work, a reconciliation that mapped every questionable expense, every approval, and every internal acknowledgement against the firm's governance policies. The pattern was unmistakable. The chain of responsibility was clear, and the authority to trigger a formal review rested squarely in her hands. Daniel's gaze shifted between Evelyn and Graham. He was now fully analyzing the institutional exposure. The deposition had become a quiet but absolute demonstration of leverage. If the partnership committee saw these documents, if the governance clause was invoked, the implications for Graham could be catastrophic. His personal indiscretions, once carefully concealed, were now inseparable from his professional standing. Graham opened his mouth to speak, to reclaim authority, but the words faltered. Evelyn's calm had stripped away the theatricality he relied upon to dominate a room. She did not need to argue. The facts presented in precise sequence spoke louder than any attempt at verbal persuasion. Miriam Sloan, sitting beside Evelyn, allowed herself a faint nod of approval. The plan had succeeded thus far. Evelyn had transformed years of invisible labor, strategic foresight, and meticulous record-keeping into tangible leverage. She was no longer the underestimated spouse. She was the orchestrator of a potential institutional intervention. The room was tense, every participant acutely aware of the shift. The first major climax, the unmasking of systemic exposure and professional vulnerability, had reached its apex. And now, Evelyn prepared to move into the final phase, turning her leverage into undeniable authority, compelling recognition of her power not just in the divorce, but within the very firm Graham had long assumed he controlled. Every small gesture, every quiet movement, every carefully arranged page reinforced the same truth. The woman he had tried to marginalize had become the center of control. And the next revelation would make that control impossible to ignore. 17. Evelyn let the pause linger, just long enough for Daniel Mercer and Graham to register the quiet gravity of the situation. She did not rush. She had learned long ago that timing could make the difference between a controlled reveal and a spectacle. The documents on the table were already speaking. Ledger reconciliations, email threads, internal approvals. But the final piece she was about to present would tie every strand together, converting quiet exposure into undeniable authority. She opened a small binder at the back of her folder. The pages were organized chronologically, cross-referenced, and annotated with precision only someone intimately familiar with the firm's internal workings could achieve. Each entry was mundane in isolation. A restaurant bill here, an apartment lease there, an expense approval noted in passing. But together, they formed a lattice of accountability, showing a repeated pattern of discretionary authority used to facilitate personal activity. Daniel's pen stilled. He leaned forward slightly, realizing that this phase of the deposition was no longer about eliciting testimony. It was about documenting a meticulously constructed chain of responsibility that, if reviewed by the partnership committee, could trigger formal inquiries and institutional consequences. He could see Graham's rigid composure faltering under the weight of what was unfolding. Graham spoke first, a controlled, measured attempt at justification. He cited client development, discretionary privileges, and the necessity of flexible accounting in high-level operations. But his words faltered against the precision of Evelyn's evidence. Each page she revealed anticipated his defenses, confirming that the discretionary approvals had been consciously exercised and meticulously documented. Evelyn did not interrupt. She allowed the evidence to unfold naturally, sliding the pages forward one by one, aligning them with the corresponding approvals and timestamps. The logic was irresistible. Repeated personal benefit facilitated through discretionary authority, corroborated by internal communications, and entirely verifiable. Each line reinforced a narrative of oversight and exposure that Graham could neither dispute nor mitigate. Miriam Sloan, quietly observing beside Evelyn, gave a subtle nod of approval. The strategy had worked flawlessly. 18 years of unseen labor. Drafting strategies, maintaining internal order, guiding operations from the shadows had been transformed into leverage so powerful it could not be ignored. Evelyn had moved from marginalization to control, from invisible participant to central authority. Daniel, now fully aware of the implications, leaned back with a subtle sigh. The deposition had evolved from a marital dispute into an institutional assessment of potential governance violations. Every careful assumption Graham had made about his discretion, his authority, and his invisibility had been dismantled. Evelyn paused, fingers resting lightly on the binder. The quiet power she wielded in the room was absolute. One final step remained: connecting the evidence to the governance clause she had revealed earlier, transforming her leverage into an actionable mechanism that could compel formal review by the firm. The room waited, almost holding its collective breath for the next move. Every subtle signal, from Daniel's tightened jaw to Graham's rigid hands, acknowledged the change. The deposition was no longer about divorce. It was about authority, and Evelyn was now in command. The final revelation, the one that would convert documentation into control, lay in her hands, ready to unfold. 18. Evelyn's next move was quiet, but deliberate. She retrieved the appendix she had uncovered weeks earlier, the governance clause embedded in the firm's founding documents and reaffirmed during subsequent revisions. Unlike the other materials, this clause was procedural and formal, not merely illustrative. It outlined that if a managing partner engaged in conduct that exposed the firm to financial or reputational risk, the referral trust associated with an originating party could trigger a governance review. The language was precise, legalistic, and absolute, and with the documents she had just laid out, The connection between Graham's personal discretion and the clause's conditions was undeniable. Daniel Mercer's pen hovered midair. He understood the gravity of what Evelyn was about to do. The deposition had already revealed financial exposure, repeated misuse of firm resources, and a pattern of behavior that contradicted Graham's previous testimony. But linking those facts directly to an enforceable governance mechanism elevated the situation from inconvenient revelation to institutional crisis. Graham shifted in his seat, the first visible sign of real tension since the morning began. He had always relied on the veneer of authority, the assumptions of trust among his partners, and the predictable responses of a spouse he underestimated. Now, all of those assumptions were unraveling. He opened his mouth to speak, but Evelyn did not allow him the courtesy. Instead, she slid the appendix across the table with measured precision. The page caught the light from the overhead fixtures, drawing everyone's gaze. Daniel leaned in instinctively, and even Graham's eyes flicked to it, betraying a flicker of apprehension. Evelyn began to speak, softly but clearly. She traced the relationship between the discretionary expenditures, the approvals, and the governance clause, aligning each point chronologically and logically. She made no accusation, offered no judgment, just facts, organized and undeniable. The narrative was seamless. Personal conduct facilitated through firm resources, documented repeatedly, and now explicitly linked to an institutional mechanism designed to enforce accountability. The room was silent. Every participant sensed the shift. Daniel's analytical mind was racing, calculating exposure, consequences, and potential next steps for the partners who would inevitably see this material. Graham's composure was cracking beneath the surface. He had spent years believing authority was absolute. Now he realized that authority could be challenged procedurally, legally, and publicly by the woman he had tried to marginalize. Miriam Sloan allowed herself a faint nod to Evelyn, signaling that the strategy had achieved its moment of maximum impact. Evelyn had transformed 18 years of overlooked work, strategic foresight, and meticulous record-keeping into actionable leverage. She was no longer invisible. She was the center of control. Evelyn leaned back slightly, letting the weight of the documents and the implications settle. She did not need to say more. The evidence, the chronology, and the formal governance clause had spoken for her. And as Graham realized the magnitude of the exposure, he understood fully for the first time that the deposition was no longer about divorce, about humiliation, or about marital narrative. It was about institutional authority, and Evelyn had already claimed it. 19. The room's energy shifted almost imperceptibly, but Evelyn could feel it in every subtle movement around the table. Daniel Mercer, normally a master of control, was now cautious, weighing each word and gesture, calculating the exposure that the governance clause combined with the meticulously documented expenditures represented. Graham Whitmore, once confident in his authority, sat rigid, his fingers flexing against the table's polished surface. For the first time in years, he realized that control could not be assumed. It could only be proven. Evelyn allowed the silence to deepen. She did not rush. Her strategy depended on patience. She had already revealed the financial pattern, documented discretionary misuse, and introduced the governance clause that linked those actions to enforceable institutional review. Now came the subtle amplification, the final stitching of evidence that would make the case indisputable. She opened the last section of the binder, which contained supporting documentation directly connecting Graham's approvals to internal acknowledgments. Emails, memos, and reconciliations demonstrated that the accounting team had processed these expenditures with knowledge of the approving authority. Even junior associates, often overlooked in the hierarchy, had played a role in perpetuating the approvals without question. The system, she revealed, had been complicit. Not intentionally malicious, but perfectly aligned with Graham's assumptions of invisibility. Daniel Mercer's pen twitched slightly as he scanned the documents. He understood that these pages elevated the matter from personal exposure to an institutional problem. Every pattern Evelyn presented confirmed the conditions under which the governance clause could be invoked. The potential for formal review, perhaps even temporary suspension, now rested firmly on procedural grounds. Graham's voice when it came was controlled but tense. He attempted to explain the discretionary approvals as standard practice, emphasizing the importance of client development and flexibility. Yet the layered documentation she had presented left no room for plausible deniability. Each page contradicted his explanation, revealing a systematic pattern of oversight or misuse that could not be rationalized away. Evelyn leaned slightly forward, placing her hands lightly atop the final pages. She did not need to raise her voice. Her calm, precise authority communicated a clear message. She had meticulously prepared for this moment, and the evidence she held had the power to compel institutional action. The room was silent, every participant aware of the stakes. Daniel's analytical mind raced, considering next steps. Graham's composure, once a shield, now served only as a thin veneer over rising panic. Even the court reporter, trained to remain impartial, seemed to sense the gravity of the moment. Evelyn spoke at last, softly but with firm precision. She summarized the connections between discretionary approvals, personal benefit, and institutional governance, framing each point factually and logically. There was no accusation, no flourish, only clarity. The evidence was undeniable. Daniel exhaled lightly, realizing the magnitude of what had just been presented. Graham's eyes narrowed, but the realization had already sunk in. The deposition was no longer about divorce settlement. It was about authority, accountability, and the power Evelyn had quietly amassed over 18 years. And in that quiet, heavy room, it was clear to everyone present. Evelyn Harrow Whitmore was no longer the invisible spouse. She had become the arbiter of control. 20. Evelyn let the moment settle before moving forward. The weight in the room was palpable, and she could sense the subtle recalibration of authority around the table. Daniel Mercer, once confident in his strategy to navigate a routine divorce deposition, now leaned forward cautiously, his analytical mind racing through contingencies he had not anticipated. Graham Whitmore, usually composed and calculating, was rigid, a thin mask of control barely concealing the tension rippling beneath. She began to tie the threads together. The discretionary approvals, the repeated pattern of personal benefit, and the institutional acknowledgement within internal communications, all were now connected directly to the governance clause she had revealed earlier. Evelyn explained the logical sequence calmly, linking each piece of evidence to the firm's procedural mechanisms. It was subtle, deliberate, and devastatingly effective. A quiet demonstration that Graham's authority could be questioned not by conjecture, not by emotion, but by the clear, undeniable structure of law and policy. Daniel adjusted in his seat, recognizing the implications. He understood that this deposition had evolved from a simple marital negotiation into an institutional reckoning. The governance clause, reinforced by months of meticulous documentation, meant that the partnership committee could be compelled to review Graham's conduct. The consequences extended far beyond personal embarrassment. They could impact leadership, client confidence, and the reputation of Whitmore Reed and Vale itself. Graham's voice broke the quiet. He attempted a defense, citing standard practice, discretion, and occasional necessity. But Evelyn countered without raising her voice, simply presenting a cross-reference chart showing the precise dates, approvals, and inconsistencies. The documentation was undeniable. The narrative of authority he had relied upon was now vulnerable. Evelyn allowed a brief pause, letting the weight of the documents and the implications permeate the room. She had achieved more than exposure. She had established leverage. Every subtle gesture, every measured placement of paper reinforced her authority. The room's attention was drawn entirely to her, yet she remained composed, almost serene. Miriam Sloan, beside her, gave a slight nod. acknowledging the perfection of the execution. Evelyn's preparation, years of unseen labor, meticulous attention to detail, and understanding of both human and institutional behavior had transformed her from the underestimated spouse to the central figure of power in the room. Graham's hands flexed nervously on the table. For the first time that morning, he realized that he could not reclaim authority through charm, explanation, or assumption. Evelyn had anticipated every argument and countered each one with precise documentation. His control was no longer absolute. It was contingent on her decisions. Evelyn leaned back slightly, her hand resting lightly on the folder. The room was charged with the quiet tension of inevitability. The first wave of revelation had reached its climax, exposing both financial misuse and institutional vulnerability. And now, the final phase awaited, the moment when her authority would not just be recognized, but impossible to challenge. Every detail, every calculation, every document had led to this. The balance of power had shifted, and the next move would make it irreversible. 21. Evelyn allowed the moment to linger, letting the weight of the evidence settle in the room. Every participant, Daniel, Graham, even the court reporter, felt the subtle shift in gravity. What had begun as a routine marital deposition had evolved into something far greater. A quiet but undeniable demonstration of authority, influence, and leverage. Evelyn's hand rested lightly on the folder, but within it lay the culmination of nearly 2 decades of invisible work. Each page, each cross-referenced memo, and each ledger entry was a testament not to anger, but to preparation, clarity, and precision. Daniel Mercer's expression was calculated but tense. He had been trained to anticipate the unexpected, yet the meticulous layering of evidence, chronological precision, and procedural foresight had forced him into a reactive stance. He realized that the deposition had crossed a threshold. It was no longer about marital financial entitlements or domestic grievances. It was about institutional accountability. Every pattern Evelyn had revealed, now linked to the governance clause she had highlighted earlier, created a mechanism that could compel formal review of Graham's authority within Whitmore, Reed, and Vale. Graham's composure was fraying beneath the surface. For years, he had relied on appearances, charm, and the unspoken assumption that his authority was absolute. Now, the foundation he had trusted, the perceived invisibility of his actions, the silence of the firm's internal processes, was exposed. Each document, each page, each meticulously mapped connection chipped away at his control. Evelyn began to speak with calm, deliberate authority. She outlined the precise link between discretionary approvals, personal benefit, and institutional exposure. Each point was factual, verifiable, and tied directly to the enforceable governance clause. There was no embellishment, no dramatization, just a clear, methodical demonstration of cause, effect, and consequence. The room leaned forward in quiet attention. Even Daniel Mercer, normally unflappable, absorbed every detail with the acute awareness of a strategist confronting a scenario beyond his original plan. Graham tried to interject, attempting to frame the expenditures as ordinary discretionary actions necessary for client development. But Evelyn anticipated the argument and, without raising her voice, presented supporting documentation, internal acknowledgments, cross-referenced approvals, and precise timing that left no room for plausible deniability. Each page reinforced the inexorable logic. Discretionary authority had been exercised in a way that exposed the firm to reputational and financial risk, activating the very clause Graham had failed to anticipate would matter. The room's energy was electric yet silent. Every subtle glance, every restrained movement signaled recognition. Evelyn had shifted the balance of power completely. She was no longer just a spouse defending her interests. She was the arbiter of accountability, the custodian of institutional authority that Graham had long assumed was untouchable. Evelyn rested her hands lightly on the folder once more. The first major crisis of authority had already rippled through the room, and the second wave, complete control and leverage, was about to arrive. The documents, meticulously prepared and strategically deployed, had done their work. Graham was exposed, the firm's governance mechanisms were engaged, and Evelyn's position as the center of power was undeniable. All that remained was the final decisive step, turning exposure into irrevocable authority. The deposition had built to this moment, and Evelyn was poised to execute it with calm precision. 22. Evelyn leaned back slightly, letting the silence stretch just long enough to impress upon everyone in the room the full weight of what was unfolding. The deposition was no longer a routine marital proceeding. It had become an arena of institutional consequence, and Evelyn had quietly seized the center. Each ledger entry, every cross-referenced email, each internal memo now verged with the governance clause she had revealed earlier to create a web of authority that Graham could neither escape nor counter. Daniel Mercer, his pen frozen, realized the trajectory of the deposition had changed entirely. The strategic maneuvering he had planned for months, anticipating objections, guiding testimony, controlling narrative, was now secondary. He was no longer dictating the flow. He was calculating exposure and contingency, acknowledging that the documents Evelyn had laid before him created a scenario far beyond ordinary divorce proceedings. Graham's hands flexed lightly on the table. He had assumed for years that discretion and appearances would protect him, that the firm's internal structures were only as fragile as he allowed them to appear. Now, every assumption had been dismantled. The discretionary approvals, the repeated pattern of personal benefit, and the corroborating internal communications, all highlighted by the binding governance clause, exposed not only misjudgment, but a structural vulnerability that could no longer be ignored. Evelyn opened the final section of the folder. This contained the complete reconciliation of every questionable expenditure, internal approval, and corresponding governance reference. She did not speak immediately. The documents themselves carried authority. Each page methodically tied personal activity to discretionary control, mapping it across time and institutional oversight. The pattern was undeniable, leaving no room for misinterpretation or dispute. Daniel's gaze moved between the folder, Evelyn, and Graham. The implications were clear. If these documents reached the partnership committee, the governance clause could compel a formal review of Graham's conduct. The very firm he had relied upon for decades as a foundation of his authority could now challenge him, and the procedural mechanisms for doing so were incontrovertible. Graham's voice was measured but tense. He attempted the familiar defenses: client development, flexible use of discretion, and ordinary business judgment. Evelyn, calm and precise, countered subtly by referencing internal emails and approvals that left no ambiguity. Each document reinforced the chain of responsibility and exposed the cumulative pattern that could not be rationalized away. The room was thick with unspoken recognition. Evelyn's composure, the careful sequencing of evidence, and the measured logic of her presentation had shifted authority entirely into her hands. She was no longer simply defending herself. She was orchestrating a process that could determine the firm's internal governance outcomes. Evelyn rested her hands lightly on the folder. The quiet control she wielded was absolute. Graham Whitmore had finally understood that the deposition was no longer about him. It was about institutional power. And Evelyn, armed with clarity, documentation, and the governance mechanism, held that power decisively. The next moment, the final action, would transform leverage into irrevocable authority, and no one in the room could prevent it. 23. Evelyn's hands hovered over the folder, not in hesitation, but in deliberate command. Every page she had revealed, the ledgers, the reconciliations, the emails, the governance clause, was now fully absorbed into the collective consciousness of the room. The deposition had moved far beyond personal dispute. It was now a demonstration of procedural authority, institutional leverage, and strategic mastery. She was no longer negotiating a divorce. She was dictating terms that could alter the very structure of Whitmore, Reed, and Vale. Daniel Mercer, who had been confident at the start of the morning, now leaned forward with a calculated seriousness. His mind was running through the chain of consequences. The partnership committee, potential internal investigations, and the reputational risk that Graham now faced. The documents Evelyn had presented left little room for mitigation. The pattern of discretionary misuse and personal benefit tied directly to enforceable governance mechanisms was undeniable. Graham's hands, previously relaxed, now flexed slightly on the table. Every subtle movement revealed tension, though his face retained an outward mask of control. He had underestimated the quiet authority of Evelyn Harrow Whitmore, assuming her labor, insight, and meticulous record-keeping would remain invisible. He had assumed appearances alone would protect him. Now, with each page and each procedural connection, he realized that invisibility had been replaced by leverage, and Evelyn held it entirely. She placed the final pages deliberately in front of Daniel and Graham. These contained a synthesis, a complete timeline of discretionary approvals, their corresponding internal acknowledgments, and the cumulative effect of repeated personal use of firm resources. The documents linked behavior directly to enforceable governance conditions. The narrative was precise, irrefutable, and methodically aligned with the clause that could compel review of Graham's authority. Daniel's pen hovered, uncertain for a moment. He recognized that the deposition had evolved into something far greater than anticipated. It was no longer about evaluating personal testimony. It was about recognizing that institutional procedures could now be activated, that authority was contingent, and that the man who had assumed control for decades was suddenly exposed. Graham spoke, voice measured but strained. He attempted to defend the pattern, citing client development, discretionary privileges, and professional judgment. Evelyn's response was simple. The documents themselves were the argument. She did not raise her voice. She did not argue emotion. She let the evidence, presented with surgical clarity, make the case. Each email, ledger, and memo reinforced the same point. Authority rested on accountability, and she had it in her hands. The room's energy was palpable. Even the court reporter seemed to sense the shift, typing with heightened attention. Every subtle glance between Daniel and Graham acknowledged what Evelyn already knew. The balance of power had shifted irreversibly. She was no longer just a party in a divorce. She was the holder of institutional leverage, and the mechanisms to enforce it rested in her hands. Evelyn allowed herself a quiet moment, letting the gravity of her position settle. The final phase, the transformation of exposure into irrevocable authority, was ready. One move remained, and once it was executed, the deposition, the firm, and Graham's assumptions about control would never be the same. 24, Evelyn let the room absorb the weight of her final revelation. The folder lay open, each page a silent testament to her meticulous preparation. Ledgers, reconciliations, emails, and the governance clause she had uncovered and connected with surgical precision. The deposition had transcended personal conflict. It had become a quiet, absolute demonstration of authority. She was no longer just a spouse asserting her rights. She was the central arbiter of accountability within Whitmore, Reed, and Vale. Daniel Mercer finally exhaled, a subtle recognition of the magnitude of the situation. His strategy to manage a predictable deposition had been overtaken by a force he could not redirect. Evelyn had orchestrated every move, every revelation with a patience and foresight that turned invisible labor into undeniable power. The implications were clear. The documents, when reviewed by the partnership committee, could compel formal scrutiny of Graham's conduct, placing him squarely within the mechanisms of institutional accountability. Graham Whitmore sat rigidly, his outward composure intact, but his inner calculation visible in every subtle tension of his body. For years, he had assumed control through appearances, charm, and the unchallenged execution of discretionary authority. Now, all of those assumptions had been dismantled. Every discretionary approval, every subtle misclassification, Every internal acknowledgement of personal benefit now pointed directly to him, and all were irreversibly documented. Evelyn began the final synthesis, tracing between personal actions, discretionary approvals, and institutional governance. Each point was factual, precise, and verifiable. She did not raise her voice. She did not dramatize. She let the evidence itself construct the narrative. Authority is contingent on accountability, and she held both the documentation and the procedural mechanism to enforce it. The room was charged with quiet intensity. Daniel's analytical gaze measured risk, consequences, and procedural pathways. Graham's attempts at defense, once reliant on charm and assumptions of invisibility, faltered against the relentless clarity of fact. Even the subtle gestures, the placement of documents, the deliberate pacing of revelations spoke louder than argument could. Miriam Sloane allowed a subtle nod, acknowledging Evelyn's mastery. Years of strategic foresight, meticulous documentation, and unseen labor had been transformed into leverage so precise it could not be contested. Evelyn was no longer the underestimated spouse. She was the orchestrator of authority, the one in command of both disclosure and consequence. Evelyn rested her hands lightly atop the folder. The deposition, now fully evolved, had done more than expose misconduct. It had shifted power, reassigned authority, and revealed the quiet truth of who truly held influence in Whitmore, Reed, and Vale. Graham exhaled, tension visible in the slight tightening of his shoulders. For the first time, he understood. Control was no longer his to command. It had been quietly, methodically, irrevocably claimed by the woman he had sought to marginalize. Evelyn closed the folder gently. A final, subtle assertion. The room's silence was complete, and in that silence, everyone understood the truth. She had won, not through drama, not through anger, but through patience, preparation, and precision. And in Boston's elite legal circles, that kind of quiet power was absolute.